the three cases that we're hearing today, yours specifically involves trafficking as well as possession. Can you talk a little bit about the distinction between that, and if you think it's an important distinction to make?
Yes, it's easier to say that the evidence suggests that proper cannabis use has no harm to others or to society as a whole. It's harder to make the argument that proper dealing and proper growing also does not result in significant harm to society or others. It's harder but not impossible if the harm reduction evidence is listened to, and I focused and totally put all my attention on that, and handing out pamphlets that show the harm reduction evidence in Caine. If that harm reduction evidence is listened to, then growers and dealers can also be protected through Section 7 and 50.
Do you think there's a danger decriminalizing marijuana could lead to increased use of harder drugs?
No. If you look at Holland and in other European cities, the result has been the opposite. And the reason for that is that when you separate the dealers, the hard drug dealers from the soft drug dealers, and in cannabis cafes, it's hard drug free. There's no more hard drug free place on earth than a cannabis cafe in Holland, because that's the most #1 rule. You get shut down if there's any coke or heroin dealt in this premise. They don't want to get shut down. They have a nice business. They keep it drug-free, absolutely hard drug-free. So you separate the hard and soft drugs. You don't have people moving on from soft drugs to hard drugs. And that's been the experience in Holland, and that could be the experience here in Canada. We could separate the drug markets.
You know, Prime Minister Chrétien said last week that he is in favor of bringing a motion in front of Parliament to decriminalize marijuana. Why do you think we're here in front of the court? Do you think the court is where this should be played out, or is it Parliament that should be dealing with this?
Oh man, Parliament has had a chance to deal with this since Ledane was put on the shelf and ignored in 1973. They have promised 13, 14 times, I lost count, how many times they promised to ease up and they backed away from that promise. The court, the ball is in the court's hands, and the court was designed to be a check on arbitrary, irrational, or protection racket, scapegoating, tyrannical government power. And in this case, there's no more glaring example of that. When you get guns pointed at your head for growing herbs, that's got to stop. They have no evidence that this is working or it's helping or it's good. There's lots of evidence that it's bad. The government's not doing anything. The government's not doing anything to protect harmless growers and harmless dealers of cannabis. If it's not the court, who's going to help these people? Decrim is not even baby steps in the right direction. Decrim would increase the likelihood of punishment, according to the U.S. ambassador to Canada. And I think that decrim is a slicker, more hard to get rid of form of prohibition, and it has to be fought with just as much energy as total prohibition has been fought. I won't be satisfied until all the cannabis growers, dealers, and smokers have all the same rights as coffee bean growers and dealers and users. And I don't, since coffee does about the same amount of harm as cannabis to society, I don't see why we shouldn't regulate it, at least on some level, similarly.
How you thought the whole day went?
I'm actually pretty impressed and really proud of all the people in the movement who have put this case together and did a really good job pleading it, had really strong arguments, and now hearing the Crown's arguments, I was, I guess, happy he helped us out. There were no ton of bricks arguments. I didn't hear one compelling argument from the Crown at all. If anything, they seemed to be fishing at best for whatever they could. And even he got stumped at one point by a question from one of the justices, and was offered 10 minutes to think about it. So I think it's going to be good news. I'm quite confident the Supreme Court's going to do the right thing. I don't know if they're going to go for the harm principle or not. That's a big thing. If they do, I suppose the marijuana thing necessarily follows through with it. If they don't, I think they might still do something positive for marijuana, even if they don't go via the harm principle. So that's, I guess, the finer points of law, which wait to be seen by the legal community. As far as the pot community is concerned, I think we made the strongest case we could for the Supreme Court. This is never going to happen again, so I can't wait for the decision.
Thanks.
Everything I always wanted to introduce in a Supreme Court hearing was there, so it's not like I can say, oh man, I feel like we didn't get it all in. We got lots in, and they've already got all the rest as well anyway. Theoretically, they should have read it and studied it, and so...
You feel pretty positive about the day, obviously.
Oh, it's a great day. See, the thing is, if we don't get the result we want, that will make that a bad day when the result comes back. But something good's going to come. I think they're going to come up with a threshold, a new threshold for that. Because I think, well, what's wrong with it if every law has to pass muster like that? Why is that a bad thing? You know, I think a harm principle is a great thing to have in a democracy, whereby you filter out bad legislation. Becomes endemic and sits around for 30, 40 years penalizing a million people. I think it's good to have the courts aware that there has to be a principle of harm to an individual against their will. The courts, like in other words, the judicial system, the prison system, imposes something unduly harsh on a person's own personal decisions.
I think it went really good. It's hard to tell what the judges are going to say without what they're going to come back with by the questions they asked, but it seemed to me like they were asking some pretty reasonable questions. I think that was fun. All the speakers seemed to do a good job. David Malmo-Levine did an excellent job representing himself. I predict the courts are going to come back with some kind of halfway measure, and we're going to see another couple of years of the government trying to beat the court standards, having to go back and claim whether or not they met those standards. But I think we're moving forwards in all the positive ways, and I'm looking forward to something good coming out of it in November.
You said they could be heroes. Tell us who they could be heroes for.
Everybody. The drug war is the largest war in the world, a war in every country on the planet, a civil war in every country, attacking the sensitive, most intelligent, most autonomous people in every country. They could be heroes to those people. They could be heroes to the people who want to see industrial hemp, the nutritional benefits and the environmental benefits put into place. They could be heroes. Well, think about this. In China, right now, the drug war, which is boistered by the war on cannabis, the drug war is responsible for many executions. In Colombia, it's responsible for many people getting sprayed with chemicals. All that could end as a result of what happens here. The ending the war on cannabis users, growers, and dealers is the first step to ending the war on all the procurers and utilizers of botanical substances, of botanical herbs that have been used for thousands of years with very little evidence of harm and lots of evidence of benefits.
The legal question before the courts is the simple possession law. You're inviting them to do a lot more than that.
No, that's not true. My argument has been from the get-go that the laws against growing, dealing, and using are all unconstitutional. They all violate Section 7 and 15, and that any harmless activity, growing, proper dealing, proper using, or any other harmless activity from now until forever, they should all be protected by Section 7 and 15 of the Constitution. And that way we prevent scapegoating. We prevent the government just pointing their fingers and saying criminal without any evidence at all, and then hundreds of people, if not thousands in this case, getting locked up as a result. If you have royal commissions, if you have Laurel reports, if you have the Senate reports, the parliamentary reports, none of which suggest a significant harm, at that point the burden of proof is placed back on the government to suggest some significant, unalterable, inherent harm with the activity. Otherwise, it should be a protected activity.